Michelle Perales, and she is an LLM candidate from UNLV. She's going to talk today about case law and problem gambling. And after her session, there will be a poster session in the hallway there, so make sure to stop, look at the posters, ask the presenters for questions, and welcome all of our amazing students who are new in our field, and we want to support them and bring their fresh minds in.
Thank you so much, Andrea. So as Andrea mentioned, hello, my name is Michelle Perales. Can everybody hear me? Okay. I am currently an LLM candidate at the UNLV Boyd School of Law here in Las Vegas, but I'm originally from San Antonio, Texas, and really just fell in love, yay. Really just fell in love with Vegas and decided to transfer from St. Mary's School of Law in San Antonio here to Boyd School of Law at UNLV. I did that in 2018 and completed my Juris Doctor at UNLV. And then I decided in 2021, like, hey, I'm not really doing much. I'm just sitting around because of the pandemic. I hadn't taken my bar exam. So I decided to enroll in the LLM program to focus on gaming law, which, as we know, UNLV specializes in. So it's been a great opportunity for me. I'm really interested in problem gambling, and what you're going to hear today is a culmination of my research that's happened over the course of several years. I actually started doing this research in about 2018. And as the case law has grown, my research has broadened in scope. And so what I'm here to present today on is how problem gambling is viewed in the jurisprudence here in the United States. I could have gone international, and that's a whole other session, but we're going to focus on the US. And I specifically want to really just delve into the question as to whether or not casinos should owe problem gamblers a duty to care. And we're going to talk about various aspects of that duty. And we're going to also look at some interesting case law. I just want to give one caveat. In the research, they rarely distinguish between the terminology of problem gambling, disordered gambling, gambling addiction, pathological gambling. So I'm going to be using problem gambling as an umbrella term to cover all aspects of that spectrum of disordered gambling. But in the clinical research, and again, the clinical aspects, the medical aspects of problem gambling as an addictive disorder, because it went from an impulse control disorder to now it's classified by the American Psychiatric Association as an addiction. So all of that clinical conversation is a whole other session as well. So I have included a little bit of that in my presentation, but for the sake of time, I'm going to go straight into the litigation landscape analysis. Okay. All right, so in my litigation landscape analysis, I have focused on 4 categories of legal claims. So in these 4 categories, the plaintiffs really did present persuasive legal reasons for a duty to care. But ultimately, the courts decided that the gambling legalization statutes at the state level overrode any private causes of action that a plaintiff can bring against a casino. And these are specifically for personal injury claims. Wrongful death, those types of claims, intentional infliction of emotional distress, negligence, breach of duty to care because a patron gets harmed as a result of gambling, addictive disorder, and problem gambling. So those are the types of causes of action I've been looking at. So the 4 legal claim categories under that umbrella are the voluntary self-exclusion programs, the extension of credit markers by casinos to disordered gamblers, the addictive characteristics of electronic gaming machines or slot machines, video poker, and then I'll be doing some Dram shop law comparisons. And I'll talk a little bit about what Dram shop law means when we get to that section. So I'm going to give you the end result first before we go into all of the deeper dive into the case law. So after analyzing all of this relevant case law, again, the question was to determine whether casinos have a legal duty to care for gamblers, specifically known problem gamblers, who are extremely susceptible to enticement, temptation, marketing, promotions, free rooms, hotels, all that stuff. That subsect is very susceptible to that, right? So the consensus is that in the law, there is no legal remedy. A duty does not exist. And we probably already know that. So on the whole, the courts have found that casinos do not owe a duty to care for problem gamblers because the states have already passed the legalizing statutes, which contain language about alternative programs that help people with their gambling addiction. So those programs are the voluntary or mandatory self-exclusion programs. Some are administered at the state level, and some are administered at the facility level. And I think here in Nevada, they're facility specific, if I'm not mistaken. And also the funds that states put together within the legalization statutes to help addicted gamblers. So that's the state's remedy. So basically, the courts have held that when they created the gambling legalization statutes, the state legislators did not intend to enhance casino liability by permitting injured guests to file private causes of action, such as negligence claims against casinos, or else, had they intended it, they would have built it into the statutory language. That's what the courts have said. So a number of courts have determined that the law intended for casinos to only be responsible to the state gaming authority, the commission or board. That's who they're responsible to. A private citizen cannot bring a private cause of action against a casino. So in case after case, the courts, and this is in the legal opinion, and in their opinions, have said that the problem gambler is a rational human being who has made the conscious decision to gamble despite any harm caused to himself or herself. So using this rationale, the courts have refused to infer a duty to care for problem gamblers upon the casinos. So as I mentioned, case after case, we see that problem gamblers don't have a legal remedy against casinos. Even, and we're going to look at case facts here too, even in cases where the behavior of the casino from a moral and ethical standpoint seems a bit dubious, and we're going to look at that. So let's start with the first category, the self-exclusion programs. Does everybody here know what self-exclusion is? For the most part? Okay. So basically, it's this notion of a patron physically barring himself or herself from the casino by, coming into some written agreement. Is it written here in Nevada? Okay. That essentially, so in that written agreement, the patron is essentially admitting that they have a gambling addiction and they authorize the casino to evict them if they're found on the casino premises. Self-excluded gamblers who initiate this written agreement, they basically obligate themselves to be arrested or prosecuted for criminal trespass if found on the casino premises. Also, gamblers knowingly forfeit all of their winnings to the State Gaming Commission or even a charity designated by the state. So I'm speaking nationwide, looking at a landscape of various self-exclusion programs. So if some of this doesn't apply to Nevada, I'm sorry, but this is just a national landscape analysis. So when casinos fail to uphold their part of the self-exclusion agreement, for example, if they fail to evict someone who's a documented self-excluded gambler or fail to ban them, does anyone know what happens? What happens if the casino fails to do uphold their part of the written agreement? Because it's almost like a contract, right? It seems, in the law, it looks like a contract. Right, so exactly. They're facing sanctions from the Gambling Regulatory Commission for failing to comply. So critics have said that this is a lose-lose option for problem gamblers because, they face all of these repercussions if they don't uphold their part of the written agreement, and they can't even find a remedy in the law, right, if they're injured. But yet they're a self-excluded gambler, but yet they come onto the casino premises and they gamble their mortgage away or their 401k or something like that, and then later commit suicide, right? So there are a lot of critics about the self-exclusion program. And really the research is saying that the existence of the voluntary self-exclusion programs they don't help self-excluded problem gamblers when they bring suit against the casinos for injuries sustained as a result of the casino failing to ban them or evict them. So when gamblers have brought breach of duty claims to the courts, the courts have immediately dismissed them. Usually there's a filing of a 12b6 motion to dismiss for failure to state a claim. It's basically a pretrial motion. So before the gambler can even go before the court and give all the facts about the ugly facts about their issues, you know, why they were continued to gamble, why the casino's at fault, that's usually the legal strategy. It's a 12b6 motion to dismiss because this person is not even stating a claim. And really, again, the courts have held that those programs, those voluntary self-exclusion programs, are there because the legislation, you know, intended for problem gamblers to take responsibility to protect themselves from their own gambling addiction. Okay, so basically, critics are saying that this program creates a false sense of security for gamblers, that, you know, it's kind of a double-edged sword. They think that the casino is trying to help them control their gambling addiction, but maybe that wasn't the case. And critics are saying that casinos essentially are creating a duty to care for gamblers when they institute these voluntary self-exclusion programs, but then fail to ban or evict, you know, uphold their part of the bargain. All right, so some researchers are, you know, saying that casinos should have a responsibility to monitor and safeguard both self-excluded gamblers and even those gamblers who aren't self-excluded, but maybe they're known, you know, problem gamblers. Like, we know they have an addiction. We know they have a problem because of all the different behavioral characteristics, right, that y'all have talked about during the 2 days. You know, so there are two reasons why the research cites for this argument. The first is a lot of critics say that casinos are actually in the best position to ban addicted gamblers. And the second, they say casinos owe a duty to monitor and protect self-excluded gamblers because they create a special relationship with them, and perhaps vis-a-vis the formal written agreement. And again, this is all objective research. This is simply research that I found. I do not hold any of these beliefs personally. And you know, it's just important to get all of this out there from the legal perspective. So researchers say that, you know, casinos have sophisticated surveillance systems, that the thousands of cameras and devices in each casino capture every gambler, you know, every chip, every slot machine, every employee, every patron, and every inch of that gaming floor. So the eye in the sky watches intently already for cheating and theft. Casinos have implemented face recognition technology, which allows them to identify patrons as they enter and exit the casino floor. Casinos have use of the Casino Information Network, which links to the biometric database of shared pictures. And face matches between the database images and the surveillance camera feed can immediately alert casino operators to the entry of a self-excluded gambler before he or she even sits down to open that purse or open that wallet and pull out that crisp $100 bill. They can identify. That's what researchers are saying. Also, the Ubiquitous Players Club program. They can track gamblers, how long they're gambling, how often, how much money they're wagering. So basically, researchers argue that with all of this robust technology and surveillance equipment, casinos should be naturally obligated to identify and monitor problem gamblers on their premises. That is why they're saying that casinos are in the best position to exclude. Some critics have argued that the imposition of a duty on casinos to recognize and remove self-excluded gamblers is a reasonable extension of the surveillance activities that they're already doing. So I think what I take from the research is that perhaps utilizing the security technology that's already in place, casinos can enhance the self-exclusion program and create a safer environment for self-excluded gamblers. So the second argument pointed out in the research is that casinos create a special relationship with self-excluded gamblers. And this harkens back to the written agreement for self-exclusion that imposes responsibilities on both the gambler and the casino. And because this written agreement exists, the law extrapolates that perhaps a self-excluded gambler could reasonably expect a casino to evict them upon entry in the premises. Some of the research argues that casinos assume an affirmative duty, which is just a legal obligation to protect pathological gamblers when they actively intervene crime of commission as opposed to crime of omission. So they're actively intervening in the addiction and learning of the person's vulnerability through the self-exclusion program agreement. If they didn't know, it might be a different scenario, right? But they're actually offering the program, so that's why some folks are saying they might actually have created an affirmative duty. So the research found that gamblers who have self-excluded commonly continue to gamble online, making mandatory or voluntary self-exclusion an ineffective gambling deterrent in online settings. And we're going to talk about sports betting in a little bit and how most of that is done online. So I don't know that the gambling industry or even the legal industry know how to monitor that under a self-exclusion agreement yet. So let's talk about granting credit markers to known problem gamblers or self-excluded gamblers. So some of the research argues that the behavior of a gambler who is spending all of his or her money and borrowing lines of casino credit to keep gambling should be a red flag to the casino that that person's out of control, right? If I am gambling all of my recreational money and spend it all, and now I'm going into debt borrowing more money to keep gambling because it's recreational, that should signal a problem. So there are several cases involving casinos enabling addictive behavior by extending markers and other sources of casino credit to known problem gamblers in the jurisprudence. One case is Caesars Riverboat Llc versus Kephart. This is an interesting case. In this case, Genevieve Kephart had already filed for bankruptcy in Iowa due to excessive gambling in Iowa. Then she inherited $1 million, and after that, she claimed that the Caesars Riverboat Casino in Indiana began sending her invitations and other promotional incentives. Caesars even offered to provide her courtesy transportation from Tennessee to Indiana. So she visited the Caesars Riverboat Casino. I would have too, I'm not gonna lie, in March of '06 and gambled all night. I'm sure she had a wonderful time, and she depleted all of her funds in one night. Then Caesars actually loaned her 6 counter checks throughout the evening, resulted in her amassing $125,000 in casino debt, which surprisingly she could not repay. So after that, Caesars sued Kephart for failure to repay the gambling markers, and Kephart countersued, stating that the casino had actual and constructive knowledge that she was a pathological gambler and had exploited her gambling disorder by encouraging her to continue gambling through providing the borrowed funds. Kephart argued that Caesars owed her a common law duty to protect her from gambling because Caesars knew that she was a pathological gambler. So the Indiana Circuit Court, they denied Caesars' trial Rule 12b6 motion to dismiss Kephart's countersuit. Then Caesars filed an interlocutory appeal. So like I said, a 12b6 motion is just a pretrial motion, right? They want the court to just dismiss the claim, like not even hear the merits of the case. But on appeal, the court reversed the circuit court's decision and held that Caesars did not owe Kephart a duty to protect her from gambling, nor did Indiana common law provide Kephart a private cause of action based on negligence against Caesars in Indiana, even though they offered her those promotions knowing that she was a pathological gambler. The court said, and again, this is going to echo in case after case. That's why I told you the results up front, because I didn't want to sound repetitive, but in the jurisprudence, basically the court says that the legislator did not intend to create a private cause of action, and that Caesars, per the gambling legalization statute, is only liable to the Indiana Gaming Commission, not to Kephart, the individual gambler. And ultimately, the Supreme Court of Indiana concurred with the Court of Appeals majority. But there was one justice in the Indiana Supreme Court, Justice Brent Dixon. In his dissent, he did call for a common law duty, and this was his rationale. He said, the result in this case, and this is the Supreme Court justice speaking, the result in this case is particularly disturbing. The court today holds that a gambling casino may, with impunity, entice a person the casino knows to be a pathological gambler by offering free casino transportation from Tennessee to Indiana, providing her with a free hotel room, food, and alcohol, and then extending her credit to gamble at the casino, where she not surprisingly suffers $125,000 in casino gambling losses. These facts call for the application of the well-established principle of Indiana common law that business owners must use reasonable care to protect their customers while on the business premises. Simple business law, reasonable care. Right? In line with Justice Dixon's dissent, researchers argue that when casinos issue markers to addicted gamblers, they should be subject to a duty of care because they've basically been put on notice of the gambler's addiction. And when a desperate gambler turns to a casino for a loan, the casino may legitimately infer that the gambler does not know when or how to stop his or her gambling behavior. So, as a result, some of the research says that casinos that extend markers have actual or constructive knowledge of a gambler's addiction and have established a special relationship with the gambler, which includes the assumption of a responsibility to safeguard the gambler from harm. So actual knowledge is just actually knowing something, and constructive knowledge is when a person is presumed by the law to know something, whether or not they actually do. So constructive knowledge is harder to prove. So the case law, the critics of the case law are basically stating that they meet both actual and constructive knowledge because the act of the person seeking loans, once they've already expended all of their gambling funds, gives someone constructive knowledge, or should, that this person has a problem. Okay, so the third category, strict product liability and addictive electronic gaming machine design. So there are some plaintiffs in the jurisprudence that have filed product liability actions against casinos and electronic gambling machine manufacturers, alleging that the electronic gambling devices, so slots and video poker, for example, are intentionally designed to exploit addicted individuals or promote addiction by pushing players to play longer and gamble more rapidly and carelessly. One such case is that of Stevens versus MTR Gaming Group, Inc. So essentially, Scott Stevens had a wife and 3 daughters, and he also gambled regularly at the Mountaineer Casino in Chester, West Virginia. He won a large slot machine jackpot, and then after that, it is said that his gambling addiction worsened over the years after winning the jackpot. So Scott Stevens ended up embezzling millions of dollars from his employer. It was an investment company. And then he used the money to gamble on slot machines. That was his game of choice, the slot machine. He hid his financial losses from his wife through keeping a separate bank account. Scott drained the couple's 401k of $150,000. He took out $50,000 out of his wife and daughter's E-Trade accounts. He maxed out all of his credit cards, and he lost $110,000 in a personal loan that he took out from PNC Bank. Ultimately, after years of this behavior, his employer found out that he was stealing money, so he got fired from the investment company, but yet he continued to gamble. He still refused to let his wife know about his addiction. And after he spent the last of his family funds, Scott ended up killing himself. And that was right after he texted his wife that he loved her. So his wife, Stacy Stevens, brought a wrongful death suit on behalf of Scott's estate against the casino and against IGT, the manufacturer of the slot machines. Stacy Stevens argued that Mountaineer Casino had negligently and intentionally breached its duty to care for Scott by allowing him to continue gambling, even though they knew about his gambling disorder. The case doesn't go into specifics about why or how the casino should have known, just to be objective. Stacy Stevens also said that the electronic gambling machines or slot machines that Scott had used had been defectively designed and that there had been a failure to warn regarding the addictive properties of the gambling machines. Stacy Stevens also sued both defendants for premises liability and intentional infliction of emotional distress. So let's talk a little bit about the electronic gambling machines. So studies show that EGMs, slot machines, video poker machines, are more addictive than any other casino games and produce the worst odds and largest losses for gamblers. By 2001, EGMs accounted for 70 to 90% of the gambling losses in casinos. EGMs are designed with structural characteristics that can influence human decision-making and behavior, such as cognitive biases and dopamine signals. And don't get me wrong, I love me some slot machines. Yes, they do release that dopamine, they really do. The structural characteristics are intended to transport, this is from the research, to transport players into a magnetic zone of certainty in an uncertain world through fast, repetitive play, high event frequency, enabling continuous play, random ratio reinforcement schedules, near misses or losses appearing as wins, multi-line betting, and exaggerated audible and visual reinforcement. They offer periodic small wins masked as substantial wins. So according to the research, machine gambling has changed the face of gambling addiction. A 2002 study found that people who regularly use EGMs become addicted 3 to 4 times faster than other gamblers, because the EGMs allow gamblers to wager faster than the old mechanical slot machines of the past, and they kind of act like psychostimulants by rapidly exciting the brain. So despite the research, and again, there's all kinds of research. There's, and I just want to preface this, there's research that extols the benefits of gambling on local communities, on economic development, on job market creation, but the whole point of this research is to be objective. So despite the research on the EGMs, the jurisprudence has refused to hold casinos and game manufacturers liable for unsafe products or defects by rationalizing that states are actively engaged in machine design through the gambling industry's regulatory scheme. So since machines operate as intended by the states, defects do not exist, and casinos nor game manufacturers can be held liable in strict liability claims. Do y'all know what strict liability claims are? They're basically like when we know something is dangerous, and you don't even have to prove that it's dangerous. It's just that dangerous, like with dog bites. In some states or counties, dog bites are handled under strict liability because we know in some states the law says that the animal, everybody knows that that animal is dangerous and can bite. So that would be a strict liability claim. So basically the courts threw out the strict liability claim in Stevens versus MTR Gaming Group. Okay, the last category, comparing this to dram shop law. So some researchers have argued that casinos should have an affirmative duty to help patrons avoid the harms of problem gambling, similar to dram shop liability. Does anyone know what a dram shop is? It's just a legalese way to say like a bar or tavern. Any commercial alcohol provider is a dram shop. So dram shop liability is the liability of commercial alcohol providers to patrons who consume excessive levels of alcohol and or third parties who are injured by intoxicated patrons. So if I'm a bar or tavern and I have a patron and I keep serving them alcohol and it's foreseeable that they're getting drunk and they're going to cause harm, I can foresee that, but I keep selling them the alcohol and then they go out and get in an accident and hit someone head on and kill that person. I, as the dram shop owner, could be liable to that third party. And in some states, dram shop owners are liable to injuries to the first party, the person who actually got drunk. So I'm not sure what the law is here in Nevada. So basically, some researchers argue that the duty to care should not be based on whether the casino knew a gambler was addicted or not, because it is hard for casinos to clinically identify problem gamblers. Researchers argue that like commercial host liability, which is based on dram shops over-serving patrons alcohol until they are visibly intoxicated and harm is reasonably foreseeable, casinos should be held liable for allowing patrons to gamble excessively without regard to their status as addicted gamblers. Because we know harm to problem gamblers is also foreseeable. I'm sure during the course of these 2 days you've heard about the plethora of social harms, right? Caused by problem gambling, divorce, child abuse, neglect, suicide. We talked about some of that in the case facts. Bankruptcy. There's like 9 categories of social harms. And there's also cost, social cost to society. So we can foresee that those costs perhaps could be an outcome of addicted gambling disorder. All right, so again, the findings is there is no legal duty in all of those different scenarios. And we talked about dram shop, we talked about voluntary self-exclusion, we talked about defective machine design. There's no duty to care and no liability. So, the jurisprudence presents a hopeless legal reality in which problem gamblers have no legal recourse against casinos, even when the conduct of casinos is questionable. So most courts have held that due to the all-encompassing statutory regulation of legalized gambling, there is no hint of legislative intent to allow injured patrons to bring private claims against casinos, right? We've already discussed that about 3 times. So here are some solutions that the researchers have found because they feel like the current regulatory scheme, the way it's set up now, perhaps may be inequitable or morally deficient. So some legal experts have proposed alternative legal and legislative solutions for injured gamblers. Now, caveat, I don't know how realistic these are, but these are just some solutions that have been put forth in the research. So the first are mega lawsuits. Does anyone recall the mega lawsuits against the tobacco and firearms industries? Okay, so some researchers are saying that states may be able to bring mega lawsuits against the gambling industry, similar to those brought against other harmful industries, okay, like tobacco, firearms, etc. In these mega lawsuits, states can hold gaming providers liable for harmful social and public health costs related to gambling addiction. So researchers draw a parallel between the gambling and tobacco industries, saying that both create a potentially harmful product or service. Both generate profit from addiction, both use predatory marketing, both use robust political contributions and lobbying to get their way, and both initiate biased industry-sponsored research. This is from the research, so they're trying to compare the two to see how perhaps a mega lawsuit may work as a strategy for addicted gamblers. So the tobacco mega lawsuits set a precedent, allowing states to file suit against an industry they had previously promoted and legalized. For example, in the tobacco litigation, tobacco-producing states filed successful lawsuits related to the exorbitant costs that tobacco-borne illnesses had thrust upon the Medicare and Medicaid system. That was the blueprint for the mega lawsuits against those industries. Has anyone here been to any sessions where they're talking about the healthcare costs or the rise in insurance costs pertaining to problem gambling? There's a whole subsect of research on the costs to society, including increased healthcare costs, increased insurance costs, increased Medicare, Medicaid claims because of addicted gambling disorder. So that's a whole other topic, but that would essentially, according to the research, be the blueprint for a mega lawsuit. Potential mega damages or high punitive damage judgments that are usually part of lawsuits may provide a remedy for harmed gamblers in a mega lawsuit type situation. The next are quid tam actions. So, and again, some of these are far-fetched, but private citizens can file quid tam actions against casinos under the False Claims Act, citing casinos' failure to acknowledge and deliberate tactics to conceal data on the negative health-related impacts of pathological gambling. So a quid tam action is one that is brought under a statute that allows a private person to sue for a penalty, part of which the government or some specified public institution will receive. The False Claims Act empowers government actors or private citizens to recover damages from individuals or organizations that knowingly presented or caused another party to present a false or fraudulent claim for payment to the government. So basically, one researcher stated that the increased healthcare costs and Medicare, Medicaid claims attributed to pathological gambling could potentially form the basis for future quid tam actions against gambling providers under the False Claims Act. Contract liability. Some research argues that since voluntary self-exclusion agreements contain the elements of a valid contract, patrons might be able to sue casinos for breach of contract when they fail to ban or eject a self-excluded gambler. So contract elements, has anyone here heard of the four corners of the contract? There's 4 things that every contract has to have to make it legally binding. Okay, so researchers say that the elements include the offer of the program by the casino, the acceptance of the program by the voluntary self-excluder, the exchange through the mutual promise that the casino will ban the patron who voluntarily admits that he or she has a gambling addiction, and then the consideration would be deemed the casino's promise to remove the patron and the gambler's promise not to enter the casino premises. So those are the 4 corners of the contract: offer, acceptance, exchange, and consideration. So again, this research just likens contract liability to the ability for a problem gambler to bring a claim against the casino for injuries sustained as a result of problem or disordered gambling. Then there are legislative solutions. So according to some studies, states are just competing for gamblers and gaming money. And I've seen this. I'm from Texas, and I see how Oklahoma competes with Texas for us. You know, they're constantly sending me marketing materials to to go gamble in Oklahoma because we don't have any casinos. But states that border each other that have casinos, they're constantly competing for, residents of states next to them to come gamble within their state boundaries, right? Because they get the tax revenue. So this research is stating that as a consequence of this state revenue rivalry, a government's ability to successfully regulate problem gambling has weakened because government perhaps is more fixated on competing for patrons. So because it's weakening, protective measures have weakened, and the research is saying that perhaps it's time for the federal government to act. So one of the suggestions was for Congress to create an independent federal gambling regulatory commission to supervise concerns such as rapid gambling legalization and the societal and public health consequences of public gambling from the federal level instead of leaving it to the states. So with that said, I'd like to take any questions if we have time.
Thank you.